Howdy Ags, it's Professor Dagnall again, and in this two-part video, we are going to talk about liens and bonds as methods of securing payment. This video will focus on liens. We last discussed payment and cash flow on a construction site and the importance of carefully drafted payment terms in the contract to properly manage cash flow. Hopefully you followed up that video lecture with looking at some of the payment terms in the AIA and the consensus stocks contracts, as well as their pay app forms. These contract terms are incredibly important and provide the framework and procedures necessary to help balance some of the risks of non-simultaneous exchange of consideration on a construction project and to help keep cash flowing. However, as Scottish poet Robbie Burns eloquently stated, the best laid plans of mice and men often go awry. And the construction industry is no exception to that rule. Even with carefully drafted payment terms and contracts, performance of the many promises set out in the contracts often goes awry. The industry has several mechanisms to help secure the performance that's required. Whether that performance is construction in accordance with the contract documents, or that performance is making payment to another party, we can use liens and bonds to help secure that performance. Understanding these mechanisms is a necessary part of fully understanding payment terms and all risk management on a construction project.
When I say both liens and bonds help to secure performance, what I mean is that they provide a kind of backup for when the original agreements or the original performance in the contract fails. They provide security or a sort of safety net of monetary value to replace the original performance guaranteed in the contract. Now let's start with the terminology and make sure you understand what I mean when I say security. We'll use an example that hopefully will feel fairly familiar to you. When you finance the purchase of a new car, that is, you take out a loan to buy the car, you make a deal with the bank. The bank will agree to give you, say, $20,000 right now today in exchange for your promise to make payments to the bank over time. Maybe you're going to make 48 payments of $500 each so that the bank out of this deal is going to get $24,000. The bank makes this deal with you because they believe you are a good risk to make the payments, but the bank is still taking a risk to give you $20,000. Most of you probably know that if you do not make your car payments, the bank can repossess your car without having to sue you. That's because the bank has backed up or secured this loan with a financing statement or a security interest in your car. You give them this security interest by contract in all of the documents that you sign when you are taking out your loan. So when a bank repossesses a vehicle and then they sell it, they apply that cash to the outstanding loan, and that makes the bank closer to whole. So let's take a look at what this looks like. If the entire performance that you were meant to give the bank was paying them $24,000, and you have paid 50% of those payments, the bank has already collected $12,000. But the bank is now in the hole for $12,000. Now, the bank can sue you because you have, in fact, breached this loan agreement. But as you know, lawsuits are costly and they take a long time. The other thing is, even if the bank gets a judgment, you might not have enough money or assets to pay the bank this $12,000. And that is why they have secured their loan with an interest in this vehicle. So if the bank repossesses this vehicle and then they sell it, it depends on the value, but there's a good chance when they repossess the vehicle that they are only going to be able to sell it for, let's say they can sell it for $8,000, something like that. My pie chart might not be accurate here, but they sell it for $8,000. And now the bank, instead of having only $12,000 and a $12,000 deficit, the bank now has $20,000. Excuse me. The bank now has about $20,000 and only a $4,000 deficit without ever having to file a lawsuit. So that security interest, or in the collateral, in this case, the vehicle, has helped provide a safety net, helped secure your lack of payment, which was your required performance on the loan. In the same way, liens and bonds provide security in the construction industry when a party fails to perform. They do not prevent failures of performance or necessarily make the non-breaching party fully whole in the event of failure of performance, but they do provide some security to manage the risk of failure of performance. Let's talk about liens first. A lien specifically protects against failure of payment only. This means that liens are protecting lower tier contractors or material suppliers who do not get paid by higher tier contractors up to and including the prime contractor from non-payment by the owner. A lien is a legal claim or encumbrance on a piece of property. It's not at all unlike the bank's claim to your vehicle. However, it arises in a completely different manner. When a bank has the legal right to repossess your property, that's because you've given them that right by contract. Lien rights, however, are created by statute, and they were specifically created by state legislatures to protect payment and cash flow rights of laborers for whom a breach of contract lawsuit was often too expensive or too slow to provide an effective remedy. You may have heard them called mechanics and materialmen's liens. That's because they literally arose out of mechanics performing work on cars and then holding the cars until they were paid for. If a mechanic does, say, $500 worth of work on a vehicle, and the vehicle owner picks up the car without paying, the mechanic's only recourse is to sue the vehicle owner over $500. It is going to cost significantly more than the $500 to sue the car owner, much less to actually recover that $500 payment. So the mechanic, without a statutory lien right, has no right to maintain possession of the vehicle and has no other security interest in the vehicle itself, like a bank would. Mechanics have effectively created lien rights by simply not releasing physical possession of the vehicle until they are paid in full for the work. From this, lien rights have evolved and have been codified by state legislatures, giving parties like mechanics or contractors and laborers who perform work on property of another via contract the legal right and interest in the property up to the amount they are owed, if and only if they follow the requirements of the statute exactly. In the case of construction liens, when a contractor, subcontractor, material supplier, or even surveyor, architect, or engineer does work on a construction project and they are not paid, the unpaid party has a statutory lien right to claim on the property itself. So the lien attaches to the real property, and that's the land on which the project is being constructed, and everything that is permanently attached to the land is real property or real estate. A properly filed lien does not give our unpaid laborer or subcontractor here a possessory right in the property. That is, they can't immediately take possession of the property, but they now have, via the lien, a security interest in the property itself, in the real property itself. By simply filing a legitimate lien, the lien holder has encumbered the owner's property. So the owner no longer has clear title to the property, and as a practical matter, This means the owner can no longer do whatever they want to with their property. It would be difficult, if not practically impossible, for them to sell the property or even potentially to refinance the project. And those are usually both very important to owners. So lien claims can provide contractors, subs, and material suppliers a great deal of leverage against the owner and everyone up their contractual chain, potentially, um, in terms of securing the payment that is owed to that unpaid material supplier or subcontractor or even the prime contractor. So I've mentioned several times already that lien claims are statutory. In order to have a valid lien claim, all of the statutory requirements must be met exactly. Generally, those statutory requirements include notice requirements, including specific information and exacting deadlines for notice and filing of the lien. Notice of lien claims must be provided to all parties in the contractual chain up to the owner. So in our example here, we have this contractor, subcontractor, who is unpaid, right? Payment has failed. If they want to file this lien, the lien is going to be against the owner's real property itself, but they have to first provide notice to everyone that they have a contract with. Because although the owner is the ultimate source of funding for all construction projects, this is the party who has failed to pay this subcontractor. We don't know why they failed to pay him. It may be because the owner hasn't paid the general contractor. It may be because the general contractor hasn't paid this subcontractor. But we know that this is the immediate party who hasn't been paid. This party's money came directly from the general contractor. So the general contractor needs to know that this party down here has a potential lien claim. And the owner needs to know that this party all the way down here, with whom the owner does not have a contractual relationship, has a potential lien claim that they want to file. So because the lien attaches to the owner's real property, it's important that every single party in the contractual chain back to the owner of the real property is notified about the lien. That notice generally needs to include several specific items. It needs to generally include the address of the property, in some states, the legal description of the property, and that's the 48 degrees north by 17 seconds, and thenceforth 45 feet until you reach a point and you turn 16 degrees north, etc., etc. That's a legal description. In some states, require a legal description to be included. It needs to provide a brief description of the work that was performed. But that can be as simple as performed mechanical contracting services. It generally needs to provide the details of the amounts owed, roughly when work was done, when the payment was due, and how late the payment is. Typically, again, liens are statutory and they are state law, so the specific deadlines vary by state and they vary by types of project. But in Texas, on a commercial project, the contractor has until the 15th day of the third month after payment had failed to provide notice. In some states, contractors have 120 days after they last performed. Whatever state you're in, there are specific deadlines that must be met. Typically, a lien itself must be filed with the county clerk in the county where the property is located, because those are public records. The deadlines for filing liens, again, will vary or can vary from state to state and can vary whether you're a prime contractor or a subcontractor. If you miss any of the required information in your notice or in your lien, or if you miss any of the deadlines for a lien claim, even by a day, you will lose your lien rights entirely. This is because American property law does not like to allow encumbrances on clear title of real property. easiest if you just trust me on this, that this is the reason, and that these deadlines are all very, very important. But if you want to know more about the evolution of American property law and the drastic differences with English property law, let me know, and I'd be happy to discuss it with you while we watch Downton Abbey, where the central drama of the series revolves around the Crawley family not having control over the property they own as a result of English property law. Another important thing to note is that most states provide a penalty if you file a wrongful lien, one that you weren't entitled to because you have in fact been paid, or perhaps a lien that you knowingly file outside of the deadlines. Again, this is because of property laws and the fact that a lien encumbers the owner's title. Now, in order to perfect a lien and potentially force the sale of the property for the payment, the lien claimant must ultimately file a lawsuit and prevail on the merits of their claim, that they have performed the work via contract, that they are entitled to payment, and that they have not yet been paid. There is value in knowing that if you prevail on your lawsuit, that debt, whatever amount of money you are owed, is secured by this piece of real property, just like the bank's loan was secured by its interest in your vehicle, which it could sell. But it's timely and expensive to get to the point of selling that property. Often, simply the threat of filing a lien or a lien notice letter provides enough leverage to get the debt paid for a couple of reasons. The owner, again, does not want its title to be encumbered, and the filing of the lien and encumbering of the title often puts one or more parties in breach of contract, particularly if lien releases for the relevant work have already been signed. In your review of payment terms and pay applications, you may have specifically come across lien releases. A lien release is exactly what it sounds like. It is a signed document that states something to the effect of, once I am paid for the work in this pay app I'm submitting, I am waiving and releasing any further right to file a lien on the project for that work, unless I expressly note an outstanding issue. Lien releases are almost always required by contract to accompany pay applications, and sometimes even implied by the contract to be included in every pay application. Take a look at AIA A201, section 9.3.3, if you haven't already looked at that. Remember, when we talked about how each pay app trickles up, so this contractor creates an invoice that goes up to this contractor, and then this contractor creates an invoice that includes their work plus this invoice, and they send that up to the general contractor, and the general contractor creates an invoice that includes this contractor's invoice, which also included this one, and then it adds the general contractor's work or overhead, and they send that invoice up to the owner, who is, again, our ultimate source of funds on any construction project. And then payment trickles back down, as you can see by these blue-green arrows that are already on here, right? The money comes back all the way back down. So lien releases are another area related to contract drafting and negotiating that need to be carefully thought through and considered to make sure that wherever you are in the contract chain, right, that if you are required to provide lien releases, you're making your subcontractors provide lien releases and requiring them to have their subcontractors require lien releases. Because what this general contractor doesn't want to do is release all claims related to this pay app and invoice and state that, hey, I am releasing all lien claims and there will be no liens filed on this property if this guy and this guy have not also provided lien releases. Because then the moment this guy is unpaid and files this lien on the owner's property, that means that the general contractor has now breached their contract because they said, hey, no liens will be filed. And in fact, this guy filed a lien. What this general contractor wants to do, they cannot, let me be clear here. Lien releases do not stop liens from being filed on the property, because liens are filed with the county clerk, and lien releases are a private matter of contract. And so the county clerk's job is not to determine whether or not a lien is valid. A county clerk's job is to determine whether the paperwork put in front of them is valid. So whether or not this guy down here has signed a lien release, even if he signed it, he can still go and file a lien. If there is a lien release, then both the owner and or the general contractor, who's now in breach of contract, can get that lien released by the courts more easily or removed by the courts more easily, but it is still a time-consuming process. But what the general contractor wants to do, if this lien puts him in breach of contract, he wants to be able to say to this contractor, you must also be in breach of contract because I required you to give me a lien release right here. And so you shouldn't allow this lien. And then it becomes a dispute between these two contractors down here about whether or not there were lien releases. But you need to carefully consider that when you are drafting. Otherwise, a general contractor like this guy can easily find itself in breach of contract if he has released lien rights and then someone underneath him goes and files a lien against the property. Now, certainly, there are more specifics to liens and lien rights, but hopefully this has provided you with a basic understanding of what a lien is and how they work. They are powerful tools in securing payment in more ways than one. And lien releases are an important contractual tool used by owners to manage the risk of liens.
But before we wrap up this video, I have one more question I want to ask you.
What if you're doing work on public property, like let's say Kyle Field or the White House, and you aren't paid? Can you file a lien against Kyle Field? Can you file a lien against the White House? Think about that. And I will answer these questions for you and many more in the second part of the video series on securing performance, which will, hint, hint, focus on bonds.